This is the Bailed Out Podcast,
You have rights. Nobody knows how to deal with the bureaucracy.
where we talk bail to keep you out of jail.
The only thing that saved me each time is I wasn't drunk.
Does that mean you're a really bad driver then?
Hosted by Sean Plotkin, a multi-generational bail agent and 5-star author, and John Roraba, a non-profit founder and attorney who has helped over 20,000 families.
We're not far right, we're not far left, we're very neutral, I hope.
Bail is the balance.
John, what is justice?
That is what the court system is there to establish.
Bailed Out is brought to you in part by searchandmate.com, Turning Leaf, and Angels Bail Bonds. Now, please welcome your hosts, Sean and John.
Hi, welcome back to the Bailed Out Podcast. I'm Sean Plotkin with my co-host John Roraba and our special guest Joe Lombardo, who is a surety expert and a bail agent. John, where did we leave off?
Greetings. So we've gotten up to the complaint being filed by the prosecutor, and now it's time for your first appearance in court.
So a complaint is, for the general audience, since I complain a lot, and I don't want you to get confused on what a complaint would be, is that a police officer and a police department have charges, and then the district attorney reviews them and decides, okay, we're going to go ahead and prosecute this, and now you have your day to appear in court, which would be considered the arraignment?
The arraignment. An arraignment is the time where you appear in front of the court and you enter a plea of guilty or not guilty. The district attorney has offered a complaint saying that there are facts that meet the elements of the law and that you should be punished. You can either agree with that and plead guilty or no contest, or you can challenge it and plead not guilty, and then the case will go on where the state has to prove the case against you.
Do you have anything to add with that?
So the initial arrest that the police officer makes is based on reasonable suspicion. So there needs to be reasonable suspicion that a crime occurred. And then when it gets to the prosecutor and the prosecutor files formal charges, that's because the prosecutor believes there's probable cause that the crime occurred.
From your experience, since you've been a cop for a while and you're not anymore, so I'm sure we can go out drinking and relax a little bit, but I guess I digress. Well, what is reasonable suspicion? Like, I could be reasonably suspicious that, if anything, but I mean, I'm sure you have a standard of care.
It's a much lower barrier than probable cause. So it's suspicion that a crime occurred.
Right. So basically, we need to have a process to determine whether, who's guilty for the crime. So we have to have a lower standard for the police officer, and that standard increases throughout the whole criminal trial to the trial presumption of guilt beyond a reasonable doubt. But the earlier stages, there's different levels of presumption.
And I say this, and I'm heading on a little bit further. I know that some people say, Sean, you get loquacious, you carry things out. But this reasonable suspicion is a very important element, because if you are in jail and you are charged with a crime, or a police officer or department is going to charge you with a crime, they're suspicious that you've committed the crime. They don't know for sure.
Right.
Some may know, but then, facts may be subjective. So this goes back to, please be quiet when you're in jail. I have many customers that aren't quiet and they incriminate themselves. Also, which goes back to reasonable suspicion. Well, if somebody's suspicious and you're going before a pretrial release officer and you're having to fill out information, you may be giving up material facts that were previously suspicions.
Absolutely. And when a detective gives a package to a district attorney to determine whether or not charges are going to be filed, the district attorney will look at each of the specific elements of the crime, and there has to be evidence, or at least probable cause, for each of those elements. They may be missing one small part of the but then they can't file the complaint because each element has to have probable cause. So any information you give at that point increases the chances that there's going to be probable cause for each of the elements of the crime that would form the complaint.
And to reiterate, and I know some other bail agents and some surety companies may get upset with me, but if you don't have the money and you're not released, it may behoove you to stay in jail and go to court, because you may not be wasting money on a bail bond where they may not have enough against you. and you end up getting released. If you don't have a job and you don't have other mitigating factors that require you to be out of jail, I know I've been arrested before, and I've spent the night and a couple nights in jail. And I mean, well, eventually I got out, but so, I mean, do you have anything to add there?
Yeah, and I think too, it's important that when someone's arrested and their bail is set based on a bail schedule, they can still wait in jail. And oftentimes defendants will want to wait in jail and say, hey, you know what, I want to see the judge as soon as possible. And that's within 48 court hours, at least in California. And at that time, at the arraignment, the judge will address the bail issue if charges are brought.
Absolutely, but it's important to know that at the time the judge is evaluating bail, they are assuming that whatever crime is alleged by the state at whatever point, if it's the booking charges, if it's a complaint, if it's from the detective has looked at it already, whatever point it's in, the judge has to presume that the crime occurred and that the person did the crime in order to set the bail.
Yes, and I think a lot of people get that part confused, that when the presumption of innocence is a trial issue.
Exactly.
It's not a complaint or bail setting issue.
Exactly. So you'll often see people trying to talk themselves out of the arrest or out of the complaint, and you're just giving information. You've got to understand it's a process. American law is very process-oriented. Our Constitution is very process-oriented. That's how we make sure that you have fairness, is that we break it out into a specific process. If you don't take advantage of that process, then you're not going to get all the protections of the process.
Can you elaborate a little bit more about what a bail schedule is?
Absolutely. So in the penal code, it lists out the number of crimes by numbers. If you look at the California Penal Code, for each of those crimes, every year the judges get together.
Which judges?
The presiding judges and whoever he chooses. There's some flexibility in who can contribute to this, but each county will publish a bail schedule, which is the amount of bail that you have to post for the allegation of each crime. Some counties are different because some will require a separate bail amount for each charge, and they add them together. Some will only charge the bail schedule of the highest charge, but those procedures are generally published. You could go into a particular county name and you could type Los Angeles County bail schedule, and it would come up in Google, right?
Or whatever preferred search engine, not just Google.
Absolutely. So the bail schedule is consistent. One of the questions you asked earlier when we were talking is there a difference if you're arrested in a little town or a big town? Usually the smaller the town, the lower the bail schedule. Yes. Not always, but generally speaking, the judges that set it every year have some reflection of the amount of money earned by the community to be able to know what is a significant amount of security to place with the court at that early stage in the process where really nobody knows what happened yet. That's the whole nature of the process, is to find out what happened. So bail schedules are typically high, because you're taking all the risk, whatever you bail out early.
And to reiterate further on the bail schedule, which goes to what we had discussed in many other podcasts about stakeholders and community and being a social fabric, if a person cannot afford something or they establish a bail amount that's lower, then you may be able to be released. But because in areas that are more dense, like LA County, Orange County, Riverside, the bail amounts are higher. And as such, with the bail amounts higher, the average family cannot afford the cost for it, thereby needing commercial bail, and by default, sureties to backstop that.
Absolutely, because what you have to set the amount of bail on is how much money do we have to incentivize a defendant to make sure they appear in court, and that may not be affordable for a family. You may not have access to enough security for a judge to feel comfortable. But bail agents allow the bringing in of the social circumstances of the defendant to be able to provide the surety's credit to be able to stand for a defendant and get them out of court and be that security.
And to the bail schedule, and I had asked this before, but it kind of, and I don't know if you know the answer. I hope you do. You have all the answers.
To try.
Who in the county is the determining judge that helps to determine the other judges to set the bail schedule?
So judges in every county will have something known as a presiding judge. It's sort of the supervising judge in some ways. He's the one that assigns where the judge's assignments are. And in the statute, it's the presiding judge's duty to set the committee that sets the bail schedule.
And this may be a stupid question, but the presiding judge typically should have the most experience or intelligence or wisdom to be able to be rely on to be doing that. And I know it's a subjective interpretation, but
the presiding judge has the votes of the other judges.
Yeah.
The other judges vote for him. So I, regardless of those other circumstances, the other judges trust him to be in that role.
so he's one of the most revered decision makers of the law that's predicated on sound judgment previously.
Yes, bail has developed throughout, hundreds of years of practice. There's the famous
practice.
saying, the life of the law is not logic but experience.
Yes.
And this is the heart of that experience. And you can always avoid the bail schedule if you think your bail is too high. Yeah. You just have to go in front of the judge and ask. But it requires that you stay in jail for a period of time. That because you have to have a fair process. You can avoid that process by paying the bail schedule, but it's based on the booking charges from the arresting officer and a generalized amount that's set once a year by the courts.
Well, and then when you have someone who waits to see the judge, generally within 48 court hours, the judge at that point he still could release somebody if he so chose.
Absolutely.
He can set a bond amount, lower, higher, same amount, whatever the judge feels is sufficient security for the defendant to return, which then lets the defendant in some form be released for the other steps of the process to take place.
Absolutely.
Instead of waiting in custody for trial.
There's a presumption of release. You need to, generally speaking, the courts will release you. Sometimes they won't require any security at all other than your signature and an own recognizance release. Sometimes they'll put various conditions on. Sometimes they'll have their own government supervisors that they want you to have. If you can't cope with the amount of assets required by the bail schedule, they will have hearings and generally you can trade less security for more conditions.
Now, to that point, to what Joe had said, and I've experienced it many a time where we've been asked to go to court with people because the defendant would ask the judge to, because many times what will happen is a client will say, hey, I'm not guilty, I'm not guilty, I'm not guilty. I'm like, all right, if you really believe that, maybe hold off. And if you want to pay me a fee to appear in court, you pay it to the judge. And if the judge determines, hey, you don't need to have bail, well, then you just pay me my fee to show up. And if you do have bail, then we credit that fee towards the cost of the bail bond. So bail agents can show up in court and sit there. And there are times where the judge may remand you into custody, or we can have a bond posted prior to being put into custody. I've had customers that have bond posted prior to being put in custody after they had a bail hearing to determine whether the amount was sufficient or not. And sadly, in a few instances, it hasn't been. In my experience, I would say, and of course, you can't determine that because you don't know what the charges and the evidence behind it and the such are. But usually, 2 out of 3 bonds stay the same. Maybe 1 out of 3 go up or go down. But it's that's a loose number from my experience. So
yeah. There's another point that I wanted to make sure is that not everybody's entitled to the bail schedule. Yes. The bail schedule is discretionary with the police. If they think that the assets that you have might be illegally obtained, or if they think that the charges are serious enough, you can be held until you can see the judge for the 48 hours without a bail schedule. Or you can put what's a hold on it for you can prove that the money you're using comes from legitimate sources as well before they're released. So there are times that there are very serious crimes, or there are crimes where somebody has, say, stolen $1 million. You don't want to set a $5,000 bail that he can get away with $1 million, right? So there are times where the booking officers can require that you go in front of a judge and you don't get the bail schedule.
So there's a judicial review that kicks in also on holds where the arresting officer may think that there's ill-gotten gains or there's serious enough charges that warrant being held without bond, and that'll be reviewed by a judicial officer prior to the hold being approved. Generally, they give about 8 out. There's about an 8 to 24-hour window to put in the application for a hold. So even very early on, you still always have that judicial review. You never have a police officer that just says, "I don't like that guy. I'm going to put no bond on him."
What's a judicial officer?
It's usually either an on-duty judge or a commissioner who's tasked with reviewing requests for holds, requests for bail increases, requests for OR releases, things like that. So it's an officer of the court.
And this person that's an officer of the court does not make these determinations typically at 3 a.m. So this could happen subsequent to a bond being posted, correct?
They're 24 hours.
Yeah, for those situations, yes, they're available.
There's usually a magistrate that's available for that. You're right. The police initiate that, but they don't approve it. There's a process for the police to say, unless the police stop it, you're entitled to the bail schedule.
Yeah.
But the police can send it for judicial review, and there's usually a fast process. But then sometimes there's also you have to go in front of the judge.
If the officer puts in the application, I don't remember the exact amount of time, but it's less than 24 hours that the court has to act on it or reverts back to the bail schedule. And then if the hold's granted, then you have to see a judge.
Wow.
But one of the times, if there's a hold, that's one of the times where a bail agent may need to come to court in order not only to post the bond, but to allow the bond to be set by the judge and the amount of the bond that's set by the judge. There are certain cases that are not bailable, so bail agents come in sometimes to have to show that the money that they're going to take is from a legitimate source.
And before we get into motions and other stuff like that, what about bail enhancements or gang affiliations? Are you familiar with any of that?
No, enhancements generally will occur at the arraignment. The police generally don't have the authority to place enhancements on people. That's
sometimes with bail, the bail schedules often will have additional bail for enhancements that on those booking charges.
But those usually, in my experience, get picked up at the court level, not so much at the police level. So oftentimes someone will bail out of jail, and then their attorney, the person's attorney, will say, "There's a chance your bail is going to go up because of an enhancement, because of prior convictions or seriousness of the charge or for some other reason." So then that's when the bail agent, another time, often they go to court.
Well, from my experience, there have been local magistrate, typically police departments, not sheriff's departments, that do have enhancements for gang affiliation, needing a larger bail amount. And it's anywhere between 20 to 50,000 if the police officer chooses to put that on. Especially here in Long Beach, South Bay area, that's what I've been noticing.
Sure.
So, I mean, do you have anything more to add with that or no?
You can tell whether or not the enhancements could go on based on the bail schedule. They'll be listed there, and they regularly. They regularly are. I think there's a lot of variation depending upon the police culture that you're in, maybe even the type of police officers you arrest. There are, of course, many police officers that specialize in gangs.
Yeah, and so in a case like that, likely that detective's going to know what enhancements exist, what tools he has, whereas a street cop who's just happens upon somebody's probably not going to.
But that's something that can be frustrating for people too, is, you might have the booking charges with a $50,000 bail, but the charges that are actually filed have enhancements or priors or 3 strikes or some other thing where they might want $1 million bail. And when you go to that first hearing for on your bail bond, the court may well remand you to custody and require higher bail.
And a bail enhancement just means an increased amount that needs to be put up to guarantee a release and make sure you appear to court. Now, to the point, the reason that I ask about this and the reason I think that it's relevant goes back to studio audience. Keep your mouth shut, because you could be in custody, and if you say something, it could raise your bail amount for different reasons. So,
well, also, when you're in custody, I want you to realize that there's a whole bunch of discretionary decisions that are being made by different agents of the government. Yes. Like all people, these are human beings. If you are rude and mean and, they're going to make discretionary choices that aren't in your favor. If you're able to keep yourself under control and at least realize that this is going to be something that's with you for months, if not years, you have to start getting used to the idea that you've got a criminal complaint, or maybe it's something that it's a bigger pattern, but have that self-control to be quiet during that period. It's hard, but it really is going to help. That politeness is going to help you get the best result from the system.
Well, and you can absolutely be polite, quiet, and respectful all at the same time.
Absolutely, absolutely.
Being quiet doesn't mean you're being combative.
Right.
Or uncooperative even.
Exactly. But there are a lot of enhancements and differences between, what is known as a wobbler. It could be charged as a misdemeanor or a felony. Whether or not the charge is a misdemeanor or a felony has a lot to do with what the police officer thinks about you, which has a lot to do with the responses that you give him. So it's being respectful to authority is the way to get out of the system as simply as you and as effectively as you can. You can find other people that you can complain to.
John, can you that's a really important thing, and I think that we should hit on it harder. Go into more about a wobbler and go into more about what the ramifications of a misdemeanor versus a felony and
Absolutely.
Why our audience should be listening to this. If you're going to listen to anything, this is where you want to listen.
That's good. If you've listened this far, keep listening. Thank you. Yeah. So there's a lot of crimes that there's various levels that you could be charged with. There's basically 4 important levels. There's infractions, misdemeanors, felonies, and serious and violent felonies. And each one is affected by bail differently. Oftentimes, if you have something like a domestic dispute, for instance, whether or not that's a felony or a misdemeanor is often a judgment call, and the arresting officers tend to favor felonies on the arrest, and a lot of times the district attorney will file it as a misdemeanor, but you've had to pay for felony bail because you have to get out. Sometimes you can have wobblers between misdemeanors and infractions, but the amount of process that you are due in the system is directly related to how much you can be punished. Yes. If you're going to be subjected to the death penalty, there's lots and lots of process. You can see my cousin Vinny has all of those dynamics in a murder trial, because that's where the worst punishment is. If your punishment is an infraction where it's just money, so you have like your ticket, you can just forfeit your bail, and that takes care of the fine. The bail and the fine are the same thing. In some states, they do that for misdemeanors. Right. You could just forfeit the bail, and that pays the fine. But once you get into a misdemeanor or felony, with a misdemeanor, the court can punish you with just a fine or with jail time or with both. With a felony, if you get convicted of a felony, you're almost certainly going to have custody time in addition to the fines. So the nature of the charges, how serious the potential punishment will determine how much process you're entitled to. And that can really change the nature of the case.
Yes. And misdemeanors, just one point is misdemeanors are punished in the county jail, and felonies are generally punished in county jail or state prison. So a misdemeanor won't go to state prison.
So if you're found guilty of a misdemeanor, you serve the time if you're going to be serving in the county jail, but you won't go to state prison.
Correct.
Right.
Not on a misdemeanor.
Can either of you elaborate further on specific charges that may be a wobbler between an infraction and a misdemeanor, and then subsequently a misdemeanor or a felony?
Sure. You could have a wobbler of an infraction to a misdemeanor, and a lot of the driving charges. A lot of the driving over 100 miles an hour. Could be either driving on a suspended license is the most common one. Yes, that could be an infraction or a misdemeanor, depending on how it's charged. Yeah. The misdemeanor to felony wobblers, there's many. There's DUIs can be misdemeanors, or they can be wobblers depending upon the history. Domestic violence is where you see that the most. A lot of the theft charges, it depends on the valuation of the theft that determines whether it's a felony over, what's the limit now in felonies?
$2,950 in California.
They may have raised that. But sometimes if someone's stolen a ring, what's the value of that ring? Is it the retail value? Is it the wholesale value? How do they determine that? So a lot of times that becomes the core of the negotiation in the case is we agree we stole the ring, but we'll agree to not challenge it as a misdemeanor, or you could take us to trial for a felony.
And this gets back into, and the reason I'm asking for that clarification is because as Joe has elucidated or helped to explain before, a police officer arrests based off suspicion, and then it goes to reasonable doubt, and there's that gray area in between where it makes sense to go to an arraignment. Another thing before we get into that is we had guilty, not guilty, and no contest. Can you explain a little bit about no contest? But I was getting to a point about needing an attorney to be able to argue the gray area, but please explain no contest.
So there's really two ways to effectively plead guilty. If you plead no contest, then the court will find you guilty, but there's certain reasons for other collateral consequences, other things that can happen off of a conviction that will be different. So for instance, if you pled guilty to a misdemeanor taking money, they might take and you're a bail agent, they might take your license. They might take your teacher's license, if you pled guilty. But if you plead no contest, then they'd still have to have a hearing at the license to prove the facts of the case, because you've not with a guilty plea, you've said, I've done it. With a no contest plea, you've said, the state has accused me of this, and I'm not going to bother contesting it. I'm just going to accept the punishment they gave me. And that prevents you from having to actually admit guilt when you're just not going to contest the process.
No contest is what is it? Nolo contendere?
That's the Latin. And
then they use the Latin to. So why else would a no contest be used besides just a separate review for licenses? Is there another reason?
Yeah, well, I mean, basically just emotional, right? I mean, you've got people who say, I'm not guilty, and you can't get them to say, I'm not guilty, but, would you go to a rehab, or would you would you agree to the punishment that the state is offering? And they would say yes, and say, well, okay, you don't have to plead guilty, you can just plead no contest. And so it lets the plea deal happen a little easier because the person's not admitting their guilt. They're just saying, I'm not going to contest the state's action.
So besides the emotional component to feel that you're not pleading guilty to something, could there be a reason that a person would say, oh, perhaps my penalty will be less if I do no? So there is no reduced penalty, no reduced anything from it. It's more of just, I want to get closure. I don't want to have to go through this, but I don't want to be claiming guilty, but I want to find a different way to.
When you plead no contest, the court will then find you guilty. So there's still a finding of guilt, but it's imposed by the judge rather than you admitting it.
Is that always?
I've never heard of a judge not accepting a no contest plea. That, where that happens, I take that back. In federal court, for any guilty or no contest plea, the judges really make sure that you're admitting to the facts, and they won't accept them sometimes. I've never seen that happen in California courts.
And just to have John reiterate again, you haven't heard it in non-federal. How many cases have you think you've seen?
So of the case files that I reviewed, I was trying to estimate that last show, and it's somewhere around 50,000 maybe. Wow. In the 28 years that I've done this.
And in your, I mean, you can estimate it out obviously. Of the 50,000, how many pled no contest?
Lots. A lot of people plead no contest. In fact, if you've made a deal, that's why I say that there's an emotional component to it. A lot of times they will plead no contest because it's hard for people to accept the guilt and say in front of a judge, I'm guilty, but they'll still accept the punishment and they just don't want to deal with the case. I'd say no contest pleas are more common than guilty pleas.
And would you say that people get attorneys and then they plead no contest,
Yes.
or typically when there's Okay.
Yeah.
So for a bail tie into this, so after the arraignment, whether the person bailed out on the bail schedule or at the arraignment,
Right.
These things take time. The process takes time, as John keeps talking about, and that's where there's also value to bail. It keeps someone free of custody while their attorney is working out a no contest plea or a plea bargain or a reduced charge, things like that. So when people are in jail, they tend to want to take the first offer that's going to get them out quickest, as opposed to let me get out, let my attorney work on this, because they take time. It's never a quick process.
Almost all cases in California are resolved by plea. We really don't have the court resources to try every case that's arrested. There's over 1 million arrests every year, and almost all of those arrests result in either no charges or pleas. So it's very important that functions, because I think if 5% of the cases went to trial, we couldn't handle it. Something along those lines.
All right, so we're hitting on about 31 minutes. We want to go about 35 to 40, so I'm going to move us along a little bit. Now, with the arraignment, let's get into what happens.
Yeah, so the arraignment is just for you to say guilty or not guilty. You have to say not guilty if you want to initiate the process. The arraignment gives you the chance. Sometimes, people just know they did it and they just want to get it over with quickly, and they want to go through the next stage, and they will plead guilty. I had a family member that did that. I don't recommend it, but now, let the process work.
Now, correct me if I'm wrong, John. On a felony case, you cannot enter a guilty plea at an arraignment, correct?
Oh, I don't know. I think you can enter guilty at any time.
I thought if at an arraignment, if you try to enter a guilty plea, the court will enter a not guilty for you until you speak to counsel.
Well, you have the right to represent yourself. So the court, it would be very strange for a guilty plea on a felony case, but it happens. It's negotiated sometimes with the attorneys, but you want to have advice of counsel before you do that, and almost every time at the arraignment you want to have a not guilty plea, because then that opens up the rest of the process for you to be able to negotiate really in many ways the rest of your life. The rest of your life depends upon that negotiation.
And have your release addressed at the arraignment if you're still in custody.
Right. If you're still in custody, right, you can ask the court to set the bail. But even if you go in out of custody, they could, adjust it at that point. But mostly the arraignments are quick. They go through and the negotiations between your attorney and the state really begin in earnest.
Well, the interesting thing is, and you'll probably be able to elaborate on it, is that cases, especially high-profile cases, they're usually the beginning and the end is when you hear about them.
Right.
For the arrest, the arraignment, and the event, the conviction or the dismissal, no, you don't hear about cases too often in the middle of the case.
Right. Well, because the case is a decision-making process. We're trying to use a societal level decision-making process, and that takes time. So the guts of it are just not as interesting as the arrest and the conviction.
You mentioned an interesting thing about representing yourself in Latin. What is it, pro per?
Yeah, pro per.
Now, let's go and let's discuss at what point, if you can't afford an attorney, one will be appointed to you. Does that happen here?
Yes, that is usually the time at the arraignment, that if you don't have counsel, that the public defender will be appointed. And that's important with the bail context, because remember, if you were released on bail and you're using a public defender, you may not even get to have them assigned until 6 weeks after the arrest. At that first time that you appear in court. So you could hire your own attorney earlier, but generally speaking, a public defender isn't provided until the arraignment. If you stay in jail and you aren't bailed out, that comes in 48 hours. Yes. 48 court hours.
Now, one element that I want to hit on that is pretty important is, and I don't think we really talked about it, is, okay, you're out on bond, you go to court, and you plead guilty, no guilty, not guilty, no contest. You apply for a public defender or pro per, or you have your own attorney. What happens in bail reform where people are cited out and then they don't even appear to court for this first court?
Right. Yeah. There's the failure to appear rates on government pretrial, especially for misdemeanor cases, are could be over 50%. It's very common that people are arrested, released, and they forget. They go about their life. They don't want to go to court. Who wants to go to court? It's a very stressful time, and avoidance is it's a tactic of the immature. There's a lot of immature people that get arrested.
So Joe had said, be respectful. You can be quiet and be appropriately act appropriately in court and with the police department and the such. To that point, how many people that post bond don't show up to their first court date?
So, it's interesting. When I review files, I only get them, at the end. That they, generally speaking, people fail to appear at their first appearance. They never show up, or they fail to appear for sentencing after the end when they have to turn themselves into jail for the punishment. So of the files that I get, the failure to appear initially is the most common because people who are going to run fast. Now, what percentage of that is of the people released on bonds? It's very small. Bail agents have the highest appearance rate of any pretrial system.
Joe, do you by chance have any numbers that you can throw out?
I don't have specific numbers, but I would agree with John that it's not many.
Well, I mean, the thing
that's the agents, that's from the agent making a good decision on taking the risk.
So when we say not many, is that like 1 out of 20 or 1 out of 10?
Between 1 out of 10 to 1 out of 20.
So we'll say anywhere between 5 to 10% of defendants that are bailed out with a bail agency don't show up for their first court date. However, those that are bail reform, up to half of the people don't show up for their first court date. So this goes back to skin in the game, stakeholders, having a community, a social fabric, all of those elements. Now, as a bail agent, what happens when I have a customer that doesn't show up in court? Hey, what happened? Oh, blah, I had this, or I was sick, or I forgot. And then it's at that point where it's at my discretion where I could do something called a reassumption, where I'm willing to reassume the liability for your appearance in court. However, if you are out on bail reform, you automatically get a warrant for your arrest? Or what happens if you're cited out with bail reform? Or no, that's different.
Well, they generally escalate really fast. So the kinds of conditions that can be imposed on government pretrial, waiving your rights to privacy, so that they can search and seize you at any particular time, wearing a GPS, being home detained, they will really escalate if you fail to appear and you're rearrested and brought back. What they don't do is spend resources with the family to try and bring the defendant back. If he catches another case, when he's arrested for the next time, he comes back and they'll try and add that together. They may not let you out on bail or on another release. They may want to hold you, if that's the case.
Generally, when a bail agent has a defendant that fails to appear, they're not always runners. They're not somebody who's truly on the run. Could be sick, woke up late, didn't have a ride, things like that. And then the bail agents, we generally do a good job getting them back to court and timely.
Generally speaking, 80% of the forfeitures in bail will be cleared up in the first 90 days.
Are there any other elements that we should talk about before we start to wrap it up?
I think we have had a good discussion.
So in summary, I think we've helped to reiterate that as a bail team, the bail agent, some surety or the police and or the bail attorney are components of an average person's release that needs bail and post-bond with the commercial surety. And we've discussed the elements proceeding and up to trial. No, not trial, arraignment. Is there anything else you'd like to add with that?
Yeah, and there's more of the of that process to come, but bail is an essential component of each of the steps of the criminal justice process, and really it enhances the effectiveness both for the defendant's family, for the defendant, and for the state to have bail at each of those processes. And I really think commercial bail agents are the best way to make sure that fairness is throughout the system.
Well, no, it lets the process play out fairly.
Exactly. Bail is the balance.
So give us a thumbs up or subscribe, review, rate us on YouTube, podcast, Spotify. What are some other ones? I don't even remember. You can take a look at my book, Get Bail, Leave Jail, on Amazon. Take a look out for Turning Leaf and or Angels Bail Bond, searchinmate.com. And Joe Lombardo. He'll be around.
Thank you, guys.
Thanks.
Excellent. Thank you so much, Joe.